Escape Chronicle. I'm Jacob McClellan. The Missouri Criminal Code hasn't had a major update since 1979. The Criminal Code is a compilation of the state's criminal violations and punishments that are attached to those crimes. Now, legislation is working its way through Jefferson City to clean up the code. I'm joined now by Pat Starke. He's the president of the Missouri Bar. Thank you so much for your time.
My pleasure. It's a pleasure to be here.
First off, what exactly is the Criminal Code, and why does it need some cleaning up?
You know, the Missouri Criminal Code is a set of statutes that prosecutors use to make determinations about whether people have violated crimes, and if so, or violated the law, and if so, what law they violated. And the legislature passes these and sets out what punishment's appropriate for certain types of behaviors. Over the years, what happens is legislatures come and go, and they change what those laws are going to be, and they get a little disorganized. It's akin to a fellow who has a workbench with a bunch of tools, and he keeps them all real organized, and then as he pulls them out for various projects, he doesn't put them back quite in the same place, and over the years, things get misplaced, and he can't quite find everything. So this revision that we're here about today is essentially about getting all those tools back in the right place to make it easier for people to use.
Like when you have that process of over 30 years of new laws, of new criminal laws and punishments, do you find that there are some inconsistencies that come up over the years?
There is. Of course, you have this whole gambit of rules that say what you can and can't do. And what happens over time is a couple of things. First of all, when we last did this in 1979, for example, there was no internet. And so since then, we've acquired internet laws. In 1979, there wasn't quite the social attitude towards drinking and driving that there is now. And those laws have all been tweaked. And when you compare what happens to each other over the years, you have inconsistencies in terms of things that should be punished harshly aren't, or vice versa. So if you put it in a uniform structure, what that does is that lets a prosecutor say, this is the appropriate charge for this case, this is the appropriate penalty for this case.
Could you give us some examples of some crimes that might be punished harshly when perhaps they shouldn't be, and vice versa, some crimes that need some harsher penalties but don't necessarily have them?
Well, actually, what we've done with this bill is not make substantive decisions, because the legislature needs to make those decisions. You know, it's their responsibility and their charge to decide, well, this is the appropriate punishment for this particular offense. What we want to do is take what those judgments are and just put them all in an organized fashion. For example, Missouri has a couple of dozen different assault statutes, and that's not how it started. We started with 4 or 5 assault statutes, but then as society decided we needed to be more conscientious about, for example, assaults on wives and assaults on domestic partners, or assaults on police officers, the like, they've made a special law with regard to that may not be quite in jive with each other. So if we put them all in an organized fashion, you can make sure that as a legislator that you are appropriately punishing an assault on a police officer as that compares to an assault on a domestic partner, as you as the legislator decide is appropriate.
So what are some of the other major changes that are coming about through this plan?
Well, the big one, of course, is with regard to the assault charges. But the sex crimes have become a little keltered, and obviously over the last 30 years, the public has become more cognizant of those types of issues, and there have been additional civil consequences related to people who get charged with sex crimes. All of that has gotten a little discombobulated, if you will, relative to each other. And so there's a big change that's going to happen with regard to the sex crime issue also.
How about with fines? Because I imagine there's been quite a bit of inflation since 1979.
That's part of it. We want to make some adjustments there, give the legislature the opportunity to make those adjustments, because in fact I don't think the fines have been changed since 1979. And while increasing the fine amount doesn't mean that that's what the penalty is going to be in a given case, it does mean that if it is appropriate in that case, that a judge could impose it. So it gives the judge the appropriate flexibility.
Let's talk a little bit about the additional category that's been added onto this. I believe it's for felonies. Category D, or is that?
It's actually Category E.
Category E.
Right.
Okay, that's right.
Yeah, there is currently, as the Missouri sentencing guidelines go, or the Missouri sentencing statute, there are 4 classes of felonies, A, B, C, and D, and they carry varying ramifications. A D felony, for example, is 1 year in prison to 4 years in prison. A C is 2 to 7. And then a B is 5 to 15, and there's a gap between that 2 to 7 and 5 to 15. And the goal, of course, is to make sure that a judge has the appropriate flexibility for the particular circumstances of each case. Well, between a C and a B, there's such a gap that we've adjusted that so that a C felony will become a more serious consequence. A D felony will move up, and then we have a new felony that's an E category.
How will that affect, for instance, or have any impact on the ability for plea bargains or anything like that, having that additional category in there?
Certainly it'll give more flexibility. You know, a significant portion of criminal cases are resolved by people pleading guilty based upon what a prosecutor says he will recommend to a judge. The public knows that as a plea bargain. And so the more tools a prosecutor has at their disposal, the better off they're going to be able to serve the public in their capacity as a prosecutor. You know, there's one other thing that I'd want to say about this revision of the criminal code that the public needs to be particularly aware of, and that is, if things are organized and they're easier to administer from a prosecution, from a defense, and from a judicial point of view, it means you're going to have fewer mistakes. And fewer mistakes mean fewer retrials, fewer subsequent hearings. And that means it's a much more efficient, less expensive system for the public. And the public obviously needs to be very concerned about what these things cost. It's a way, if we can get this organized, to save the public money.
How about with drug possession charges? For instance, first-time marijuana possession. Are there any changes with anything like this?
Well, there will be some consideration. You know, the substantive decision about what the appropriate penalty is for a marijuana charge, a first-time marijuana charge, should be and is in the hands of the legislature, and they will make the ultimate call about what ought to happen on that kind of a charge. A couple of years ago, we did make some revisions, not on that kind of charge, but on some other first-time offenses that essentially took the jail sentence away, because most first-time offenders on those lesser offenses don't get jail sentences. That was important for purposes of whether somebody needed to get a public defender or not.
How does this make the justice system just a little bit more transparent for the public?
Well, remember, what a criminal code is a set of rules to the public that you shall not do such and so. And if you do, you can expect consequences as are defined by these rules. It's a thou shalt not. It's a set of commandments, if you will. And the easier those are to understand, of course, the easier it is for the public to comport its behavior to whatever those rules are. So the whole goal is to make it simple, because fundamentally the rules are simple. Don't hurt other people, don't take other people's things. And to the extent that we complicate that, we make it harder for people to obey. And we want people to abide by the law.
In the big picture, really, who does this impact? Does it impact attorneys? Does it impact folks that break the law? Does it affect corrections at all?
Well, last time I looked, most criminal defendants weren't scouring rule books looking to see what their behavior was going to do.
Let me check the criminal code before I go break this law.
It doesn't quite work that way. I've never seen a drunk driver look at a book before he got in his car to drive home. But you know, the people that'll impact the most are the people who are professionally in the system: prosecutors, defense attorneys. It'll affect the judicial system itself, parole officers, the correction system, simply because they're the ones that work with it day in and day out. Now, the public will be impacted indirectly from a financial perspective, as we've just described, and in the more general sense that if they want to look at what those rules are, they'll be easier to understand.
We've been talking today with Pat Starke. He's the president of the Missouri Bar. Thank you so much for your time. It's been a pleasure.
Thank you. It's been my pleasure to be here with you today.